Thank you very much. Madam Speaker, it's a pleasure to contribute on this Urban and Regional Planning Professional Bill 2019. But before I get into my detailed contribution, I would like to respond a little bit to the member for Muruga Tableland and some of the comments that he made in this debate. And I would like to remind him, Madam Speaker, that right in Muruga Tableland, and I'm reliably informed that there are HDC developments without any planning approvals as I speak. And I make reference to Gomez Trace, Phase 2 Muruga. So as the member for Muruga Tableland stood and talked about, planning and how good it is that the government is coming with this bill, what I do not agree with in terms of his criticism on this side was that here it is, a member of parliament for a particular area standing, speaking about this bill, but would not identify some of the issues within his own constituency where there are no approvals for HDC. And I just want to give a little bit of detail with respect to this. According to the Princestown Regional Corporation, no approval were given for 80 reinforced concrete structures at Gomez Trace, Phase 2 Muruga. There are roads, drains, water, and electricity existing in the development. People are living in this development, and the Princestown Regional Corporation records indicate that no approvals were granted for the subdivision and layout of the houses existing in this particular area. And therefore, Madam Speaker, and as the Attorney General in piloting the bill spoke about bringing structure, these are some of the issues that the member for Muruga Tableland needed to highlight and not chastise and criticize my colleague from Caroni Central. And I will move on that. Now, Madam Speaker, like my colleagues before me, I want to express my dissatisfaction with the erosion of the 3/5 majority that is required for this bill. And I want to support my colleagues and the opposition here in stating that these fundamental rights of Section 4 and 5 should not be so easily pulled out of pieces of legislation spontaneously like the Attorney General has done here this afternoon. And therefore, for the Hansard record, I want it to be known that the Member of Parliament for Couva North continues to be dissatisfied and not agree with the AG with respect to eroding these fundamental rights, Section 4 and Section 5, that is enshrined in our Constitution when it comes to legislation and passing legislation in this House. I really don't know what he's trying to achieve by this, because initially we agreed to this bill, even though it's not the version that we would have had in 2014, and I will get into that a little bit with respect to the version we had and we laid in 2014 and what is here before us now this afternoon. Now, Madam Speaker, Muruga Tableland also went on to stress about Central and South being flooded and why it was being flooded regularly, annually now. And I took umbrage to that because I am a Central MP, and I want to say today, everywhere in Trinidad and Tobago floods. Everywhere it floods. Rain just has to fall for a couple of minutes, Port of Spain is underwater. Sometimes there are major landslips and landslides on the northern range. Central floods, the east floods, the south floods, everywhere floods. So to really come here to the chamber, Muruga Tableland, the fellow he is, and to identify South and Central again, trying to accuse us of not wanting to support the bill, even though our constituencies flood out, I want to remind him that the entire country is under strain from flooding and the effects and the impacts of flooding, landslips, and landslides. And therefore, we have to move together to solve some of these national problems that afflict us daily. Flooding is one such, traffic is another one that we need to address. So the member for Muruga Tableland was being very disingenuous with his comments. And like my other colleagues, we are always baffled when he gets up and stands up to speak. Sometimes we can't understand what is being said on the other side. But we leave that down and put that down to a comprehension issue on the part for the member for Muruga Tableland. Madam Speaker, I also want to say that with the advent of social media, what has come to the fore in terms of, over the past couple of years, are people vent You know, issues are brought to the fore very much so via social media. Over the past couple of years, there's been an increase in that. And you would usually see people venting or talking about or having a forum or discussion on issues with their local government bodies that represent them in terms of the regional corporations or the borough. And one of the issues that I, as a member of parliament, also has been bombarded with is that of the role and function of the building inspector and the inspectorate at that local government level when it comes to approvals for lands and buildings. And as it is at this point in time, and if it is that the government was serious about local government reform, and I'm sure they would have identified in their consultations that there's a serious problem with the process with respect to the building inspectorate and how land and buildings are approved going forward. So the process as it stands, because this is about planning and trying to create this regulatory body of planners, urban and regional planners, that would now make policy and guidelines and for the country, we have to deal with some of the issues. Because when you are at the top and you have this council of urban and regional planners making policy, planning, spatial planning for the country, responsible for spatial planning for the country and all of that, what happens next? What happens next? The local government bodies are in charge of now supervising and making sure that communities within the country adhere to proper rules and regulation and approve buildings and land that, of course, would see for holistic development of communities. So the process at the local government level is that, first of all, the building inspector is not mandated to attend public meetings, council meetings. He's not mandated. Therefore, issues that can come before council with respect to buildings, approval for buildings and land, he's not privy to that. In addition to that, he attends statutory meetings, and there is one building meeting that he attends during, probably monthly, once per month in council. So as it is, you make an application for approval for your building, for your land and building. It goes to the building inspector, and then it goes to the CMOH, or public health, where it has to be checked for proper drainage, proper roads, and all accompanying infrastructure that would make for a proper community. After that is done, a site visit takes place, and if it is that you fail on that site visit, meaning that you have not met the requirements, then it has to go back to the building inspector, and you as an individual have to improve your land or your building so that it reaches that level of approval. But what is the catch here is that even though the council can approve plans, which they do in lieu of the building inspector not doing so, the CEO has to sign off on these approvals. And for me, that is the catch there. I think that this process and this aspect of approvals for building, land and building, needs to change. It needs to change to make the approvals at the local government level much more effective. And then this results in constituents having application for approvals for years lodged at the local government level. For years, because it's a back and forth sort of scenario. I have heard stories where on the CEO desk of particular regional corporations and boroughs, like my member from Caroni Central spoke about Tunapuna, where on the desk of the CEO it has been there for months and years and no approvals are being given. So as a member of parliament, I would like to see this aspect change, and I would hope that that change would come from the top with respect to this urban and regional planning profession bill, where these professionals would now be responsible for laying down the groundwork and the policy for development within our communities. Now, Madam Speaker, the role of our urban and regional planners are to develop plans, programs for the use of land. Their plans help create communities, as I mentioned before, accommodate population growth, and revitalize physical facilities in towns, cities, countries, and metropolitan areas. The roles of the planner can vary somewhat, but the overall goal is to help develop cities into functional, thriving areas that can accommodate the population and offer a pleasant place to live and work. A strong knowledge of the regulation and codes to make sure everything is legal is required. And it includes gathering and analyzing of data, looking at site plans from developers, figuring out changes that need to be made to proposals, and going into the field to look at factors that affect development. Now, Madam Speaker, in the bill, Clause 5 of the bill, that deals with the composition of the council. And I want to suggest, again, going back to that local government level, that it mirrors, that a council be set up and which mirrors the urban and regional council that we are trying to set up here via this piece of legislation. So I want to suggest that each corporation or borough have a member who has one vote, but at every region there should also be a special council comprising either of locally elected officials, meaning the councillors, or lay citizens, provided that at least 2/3 of the voting membership are locally elected officials. And as I said before, councils already exist, so probably those councils can be tweaked to accommodate for this council dealing with approvals for land and buildings. And it would prove to be very efficient because, again, as I say, as we create this council here of urban and regional planners and the policy and the plans are laid out and it's rolled out to the various areas, then who is there to really enforce and monitor such development at the end of the day? So that is why I'm suggesting that we have a mirror council at the local government or a special council at the local government level, which will include the building inspector, the councillors, and other lay persons from within the communities who will be or may be affected by developments like this. So I'm talking about stakeholders from sporting organizations, religious organizations, and just normal laypersons, business organizations also. And I think that this would make, because, and I draw reference to the model that has been implemented in Florida. And this model seems to be very efficient and workable for the constituents and residents across here. So I think that it's worth a try in terms of speeding up the process and the backlog of approvals that you have for buildings and land approvals at the local government level. Now, I just want to also flag that I know that the government had an issue when the member for Caroni Central spoke about the composition and the autonomy given to the minister in terms of the composition of council. And I refer to Clause 5, Section 1, where 4 of the 7 members of the council are nominated by the minister in his discretion. Now, in my view, this can well lead to a politically appointed majority within the council, which may or may not have the effect of imposing onto a body corporate that governs professional and experts in the field, and dangerous political influence and control. Now, it is robustly suggested that the members of the council and the alternates be appointed by the minister on the advice of or in consultation with an independent technocrat body or some other safeguard mechanism. And this is recommended in respect of Clause 5, 1, 3, and 4. Now, I just want to remind the House that in 2014, in the incarnation of the People's Partnership version of this bill, Senator Faris Al-Rawi made heavy weather, and I quote, heavy weather of the fact that most of the council was appointed by the minister. He's referring to the same as rather unusual for the minister to have the discretion to appoint 3 of the 5 members of the council, 2 appointed by the TTSP Association. And what is even more striking, Madam Speaker, is that in this present 2019 bill, it is the then Senator, now Attorney General, who has redrafted the bill not only to enlarge the composition of the council from 5 members to 7 members, but to give the minister more autonomous power to now appoint 4 of those members as opposed to the 3 previously in 2014 where he had a problem. So I just want to flag that for the Attorney General, and probably he can give us some clarification with respect to his stance then and what has changed to make this even more so now in terms of giving the minister more powers. Madam Speaker, I also want to say that all governments may have the perception or have that perception on the Transparency Index. And this is what Senator Faris Al-Rawi said. But we as legislators need to make sure that the proximity between minister and functionaries is guarded, at least in the manner it, meaning the council, which it is composed, and as we say in Trinidad, how it go look. And I quote from the then Senator Al-Rawi. And I move on, Madam Speaker. Clause 513 states that the council shall comprise one person representing the public interest, without any further qualification that that person be possessed of the relevant knowledge or experience in urban planning. The mischief here, as far as I'm concerned, Madam Speaker, is that with a mainly ministerial appointed council, the one person representing the public interest can broadly be speaking to really anyone who fits that definition. So having regard to the power and overall functions of the council, including revoking a person's license, this subclause ought to be qualified by some reference to the urban planning field. Clause 5A. Now, in Clause 5A, because I really don't want to go down the road reading all of it in detail, but I will just give my recommendation or our recommendation across on this side. So for Clause 5A, and say for Clause 5.1b, given that this council is novel to Trinidad and Tobago, it is strongly suggested that the professions of members be further qualified by years in practice. And I know that in some of the clauses they have 2 years, 3 years, but years in practice should be something that is identifiable within the particular clause. For example, and I'll give an example because the member for Digomata Northeast doesn't seem to understand. For example, under the Planning and Facilitation of Development Amendment Act 2019, Section 13.2 provides that the National Planning Authority be comprised of a Director of Planning.
Digomata Northeast, I think we all recognize that you're not in the debate. I hope you recognize that too, because I'm hearing you. Member for Couva North, please continue.
Thank you, Madam Speaker. Thank you, Madam Speaker. So I'm just trying to clarify for him, because he seemed to not understand, that this Planning and Facilitation of Development Amendment Act 2019, Section 13.2, provides that the National Planning Authority be comprised of a Director of Planning with a relevant degree and at least 7 years of years in practice. The Chief Building Officer must have qualifications and at least 7 years in civil engineering, and the Chief Enforcement Officer and the Attorney at Law must have experience and at least 7 years in practice. So this is what we make reference to here, Madam. Section 5.4, and I asked the question, which the Attorney General can feel free to clarify in his winding up. Why is there a need to appoint alternates on this council? Why? And I would like to hear that reason why. Clause 8, vacancy of office, Madam. Now, the existing clause says the minister may remove the member from office if the member is, and it goes on to say, and then there's a, now we looked at the Public Procurement Disposal of Property Act, Section 12.1, where the president is given that power to remove a member from office upon being not satisfied that the member is, and it goes on like that. So probably we can also look to mirror what is taking place in that procurement legislation and put it here towards this urban and regional planning facilitation bill, profession bill. I move on, Madam Speaker. Clause 8.3a. You have that clause, unable to function because of a physical or mental disability. And then in the Public Procurement Act, you have Section 12.1b, is incapable of performing the duties of a member. And we are suggesting that it should be deleted and replaced by unable to function because of a physical, mental, or other disability, or, but for such disability, is neglectful of his duties as a member. Section 8.3b.
Kubanot, just for
Sure.
correction. The clause you mentioned does not say disability. it says illness. So it doesn't say physical disability, it says physical illness. There's a,
It says physical or mental disability.
no, in what we are dealing with here, you said the minister may by letter address remove a member if he's unable to function because of physical or mental disability. It's illness. There's a big difference between an illness and a disability. Thank you.
Thank you. All right. So thank you for that correction. And I move on. Section 3B, absent from 3 consecutive meetings of the council. That is the Urban and Regional Planners Profession Bill. For the Public Procurement Bill, Section 12(1)D, has been absent without the leave of the board from 3 consecutive meetings of the board. The words "without leave of the council," madam, should be inserted after the word "absent" to now read "absent without the leave of the board from 3 consecutive meetings of the council." And to us, this insertion allows for a more equitable approach to a member's removal of the council. Clause A3C, convicted in any court of a criminal offense under this act or which carries a penalty of imprisonment for a term of 6 months or more. In the Public Procurement Act, madam, Section 12(1)G has been convicted of an offense punishable by imprisonment for 1 year or more under the offense under this act. Madam, we are suggesting that this be changed by stating convicted of an offense punishable by imprisonment for 6 months or more, or of an offense under this act. By this amendment, madam, conviction for any offense under the act warrants removal from office. Another clause that we want to suggest some changes to is that of clause 15(3)A, where we want to suggest, and I'll read the entire clause, subparagraph 3 and 4 makes provision for 2 scenarios respectively. First, when applicant has a BSc, and second, where the applicant has an MSc. This subclause should be amended by removing the "and" after the word "degree" in subclause 3 and replacing the same with "or." It cannot therefore be that the intention was for these 2 subparagraphs to be read conjunctively. There's just a Clause 15(3)C, another suggestion that the opposition is putting forward to the House is that of clause section 15(3)C. You see, madam, if the member for Degomata Northeast would sit and listen, probably he'd learn something, you know, but this kind of arrogant nature, I don't understand. So, clause section 15(3)C. It is respectfully submitted that a police clearance should be a requirement for any license, and that clause 15(C) should be amended accordingly. Clause 19(4), madam. Should this not also apply across the board to professional and provisional licenses? And that's just a question I'm asking for the Attorney General to clarify as best as he can. Now, Clause 21 states that a license shall be in the form set out in the 5th schedule. Forms 1, 2, 3 of the 5th schedule deal with a professional license, provisional license, and temporary license, respectively. In each of the forms, the fact is that the license holder is duly registered and is referable in the past tense, not the present tense, as it ought to be. This certifies that was duly registered to practice should be amended to read is duly registered. Clause 22, clarification. We need clarification on clause 22, if only for the Hansard record, madam, on what exactly constitutes reasonable remuneration and what guidelines will be used to determine such reasonable remuneration. Clause 25(2). We are suggesting that some reasonable time limit should be inserted for clause 25(2). Clause 34 states that the council shall appoint a recognition committee and a disciplinary committee. Each committee comprises 5 members. There is no mention in the Act of remuneration for members, which must be addressed. So the Attorney General will need to tell us whether or not these 5 members will also be remunerated. There is no fund established under this Act, which is in contrast to the Consolidated Fund for the Law Association, which was established by Section 54 of the Legal Profession Act, or the Medical Board established by Section 35 of the Medical Board Act. So this matter requires further attention to whether or not you want to actually have it in the legislation for remuneration. Clause 36(3) states that the members of the Recognition Committee shall hold office for a term not exceeding 3 years. In light of the fact such members, at least 3 of the 5, are planners, and in light of the further fact that the planning community pool in Trinidad and Tobago is a very small one, would it not be practical to indicate in clause 36(3) an eligibility for reappointment subclause? It is also to be noted, Madam Speaker, that no term is stipulated for members of the disciplinary committee, although it appears one was contemplated by clause 47 of the bill. It cannot be that the term of office for members of the disciplinary committee was intended to not end. Clause 53(2)(b) speaks to the revocation of a license or removal of the person's name from the register. And I just want clause 53(2)(b). So clause 53(2)(b) should be amended by deleting the or after license and replacing same with the word and, such that it shall now read, revoke the license and remove the name of the urban and regional planner from the register. And these are the opposition amendments, Madam Speaker.
Stock is becoming unbearable, and while I understand banter and cross-talk, I don't want us to fall into the same difficulty in the last debate where a member thought that the cross-talk was not banter and that it prevented his own contribution. So I'll ask both sides to maintain their silence, please. Member for Couva, North.
Thank you, Madam Chair. I won't be too long again. Clause 60 with respect to the regulations. Now, given the observations above as to the ministerial discretion, it should not be taken for granted that subclause 2 of this clause intends the minister's consultation with the council. Subclause 2 should therefore be amended by inserting after the word minister the word after consultation with the council. And that would be consistent with subclause 1. So that subclause 2 will now read, without limiting the generality of the foregoing, the minister may, after consultation with the council, make regulations for. And it would continue. I move on to clause 61 of the bill. Now, notably, Madam Speaker, in our estimation as the opposition, we see this as not empowering the minister after consultation with the council to, by order, amend the 6th schedule, that is the Code of Ethics. The minister is asked to clarify how the Code of Ethics may be amended should that need arise. And Section 35 of the Legal Profession Act states that the Code of Ethics may be amended by the Council of Law Association with the approval of the Chief Justice. So, Madam Speaker, these are some of the amendments that we as an opposition have put forward to this bill. In addition to that, there are some comments that I would also like to make that we observed as an opposition. And it is that of the regulating, that by regulating the planning profession, the small number of planning professionals in Trinidad and Tobago will be incentivized and increase membership, given the infrastructural development route to which the country aspires. This increased number of planning professionals would inevitably assist the management, modernization, and regularization of urban planning. So, Madam Speaker, these are some of our amendments and comments that we have put on record and on the Hansard, and hopefully the Attorney General will be kind enough to consider what we have put forward. Now, Madam Speaker, again, I want to reiterate that, again, as we come with this professional bill, urban regional planning professional bill, that whilst the intentions are all good, again, I want to stress and summarize in my conclusion that we do not agree with the erosion of the 3/5 majority, as my colleagues further previously stated. And in addition to that, from the then Senator Al-Rawi's statement with respect to the power of the minister being given with respect to the composition of the council, I would really love to hear his clarification for now in this version of the government's bill as to why he has given the minister more autonomy over the composition of the council. With that, Madam Speaker, I thank you. Thank you.
I'm very pleased to have heard the contributions from the honourable members of this House, and I propose to address the germane issues that have arisen thus far. Madam Speaker, I thank the member for Moruga Tableland for putting this bill in very sharp focus. The honourable member said specifically that this is a long bill for a short issue. This bill before us today deals squarely with an act to establish a council for urban and regional planners and to provide for the regulation of the urban and regional planning profession and other matters incidental thereto. In the structuring of the bill across the 8 parts, the 61 clauses, it really is quite simple. We are firstly establishing the council. We are causing a system of licensing of urban planners and regional planners. We're registering for urban and regional planners. We're organizing committees, 2 committees in particular. We're managing the methodology for disciplinary proceedings. We're dealing with offenses and penalties and then miscellaneous provisions. I listened across the other 2 meetings that I was having at the same time to the member for Couva North, and I'm not quite sure that she came on the same bill that we did. The references made by the honourable member to clauses are not clauses in this bill. The numerical references find no place in the bill that is laid before this House. Similarly, her reference to the schedules as well. Perhaps it is that the honourable member is busy in this election season and had someone write something for her, which was drafted on something else that is not before this House. But I would take that as just classic UNC preparation and nothing more. Madam Speaker, when we deal with the structure now, this law before us, there was a most astounding contribution coming from the member for Caroni Central, and then there was quite a sensible, at first blush, contribution coming from the member for Tabakit. Now, I confess to having great regard to the contributions coming from Tabakit. In his submissions, he's often taken the role as an elder statesman in providing his reflections. So I mean this with the greatest of respect as I address my colleague, the member for Tabakit. Madam Speaker, the member recommended that we enter into a definition of urban planners. But Madam Speaker, I took the member at face value and then I pulled up the following laws. The Legal Profession Act, Chapter 9003, Act number 21 of 1986. The Dental Profession Act, Chapter 2954, Act number 16 of 1980. The Engineering Profession Act, Chapter 9001, Act number 34 of 1985. The Architecture Profession Act, Chapter 9002, Act number 19 of 1992. The Land Surveyors Act, Chapter 5804, Act number 33 of 1996. And Madam Speaker, every single one of those acts which regulate via the creation of councils for those bodies, the Dental Council, the Medical Council, the Law Association, not a single one of those bodies treats with the definition of the profession. There is no definition of what a lawyer does. There is no definition of what an engineer does, a doctor does, a dentist does. None of them enter into that realm because the practice of law, the practice of medicine, the practice of dentistry, these things evolve. They are not static. Subspecialties arise on a constant basis. What we have, Madam Speaker, is parent law, Act number 10 of 2014, a springboard in that parent law, which is Part 7, beginning at Section 73, which says that there will be a regulation environment for all regulated professionals, land surveyors, engineers, architects, Madam Speaker, and very importantly, in this law, they specifically talk to an urban and regional planner registered under the Urban and Regional Planning Profession Act. So I respectfully submit to my learned friend from Tabakit that there's no need to condescend into the particulars. I believe that my friend can also be comforted by the fact that we speak to what the qualification requirement for the licensings look like. In speaking to temporary licenses are granted to foreigners, put quite simply. Non-CARICOM, non-residents, non-citizens fall into the category of temporary licensing, i.e. foreigners can be temporary licensed. Provisional licensing and then standard full licensing are where we treat with CARICOM, resident and professionals in Trinidad and Tobago. It is there that we specifically speak to, and it is to be found in the licensing regime sections, we speak to the qualifications that people must have in urban and regional planning. It recognizes off the bat that you may have a BSc qualification in planning, as well as a master's qualification. If you have a master's qualification, they require 2 years experience to be fully licensed. If you have a BSc, 3 years experience. And that is as simple as it gets. I think that that is well in keeping with the legal profession arrangements, the dental, etc., because we say MBBS for dentists, DDS for dentists, MBBS for doctors, DDS for dentists, BSc, of course, in certain subsets if we're dealing with pharmacy, and when we deal with lawyers, we're talking about a Bachelor of Laws and LLB. So we're well in keeping with the architecture as to how we do these things. Madam Speaker, the concept of ministerial control. First of all, I'll go through it chronologically now. The member for Caroni Central. The member for Caroni Central, I understand, is fairly passionate about this area. As the minister with responsibility for planning under the UNC government, he presided as chairman of the Joint Select Committee and piloted legislation in the Senate and in the House to birth the Planning and Facilitation Development Act. It was in that act, Madam Speaker, that we created Part 7, beginning at Section 73, that dealt with the regulation of listed professionals. The honourable member says, first of all, that he takes exception to the 3/5 majority. And then he makes a broad brush castigation against me in particular, saying that I somehow, and I'm paraphrasing as I understood it, that I supposedly have a penchant for removing 3/5 majority law. Madam Speaker, he then gave an example in respect of that. And I wish to just categorically say that a 3/5 majority support is constitutionally required only if it is advisable that it must happen. I hold the position of Attorney General of the Republic of Trinidad and Tobago. At present, being a person in a revolving door, you yourself, without bringing you into the debate, have held that position, Madam Speaker. The point is, the Attorney General advises the government on law. And the law is pellucidly clear, Madam Speaker, that a 3/5 majority is not required. And that is why I spent a significant amount of time anticipating my colleagues' submissions when I indicated that we would be removing the 3/5 majority support by setting out the dicta and the cases in the European Court of Human Rights, Canada, the United States, Barbados, and Trinidad and Tobago. So like it or not, the honourable member cannot compel an Attorney General who has a considered view that the law does not require 3/5 majority support. I have shared with the world, and it is now on Hansard, the reasons that I have advanced for that purpose, and I am entirely comfortable in the law that that is the case. I even gave the precedents for my decision. Of all of the professional bodies listed, the only one that was passed with a 3/5 majority support was the Legal Profession Act in 1986. And that was then when the climate in the courts suggested that there was a need for 3/5 majority for the issue of mandatory association, mandatory membership. The case law is now absolutely clear for decades since 1986 that you don't need that, and therefore, Madam Speaker, that is why I've done that. Member made a very bold assertion, saying that the Society of Planners, which is an act in 1974 which established a very general piece of law, that the Society of Planners said that they took exception, and he made the submission that the Attorney General will be breaching an undertaking to bring a 3/5 majority support. I have had the benefit of having direct confirmation sent to me this afternoon that the Trinidad and Tobago Society of Planners said no such thing. What they said is they want mandatory membership so that they can exercise as a public body a public purpose for the public interest and the public good. They never said that they were wedded to having a 3/5 majority support. They never said that. And to just stand there with aplomb, with a sober tone, to stand up and say in the manner that the honourable member presented it, I think really reeks of a purpose that I really don't want to attribute to my learned colleague. He ought to know better, Madam Speaker. Madam Speaker, we then saw the position of the right to property. There was a song and dance submission. The honourable member for Caroni Central said he is concerned about the right to work. And then I said to the honourable member, in crosstalk, I confess, I said, but isn't the right to work ultimately the right to property? And then he stood with some chagrin and said, well, I didn't interrupt you. And then proceeded to interrupt Dr. Francis Maruga Tableland non-stop in his contribution. So I'm warning the honourable member that I take no advice from him on interruptions henceforth, because he does not practice what he preaches so boldly here this afternoon. And let me say this. The right to work carrying itself forward to the right to property, Madam Speaker. That's ultimately what it is. What are you working for? There's no right to work. There's a right to property in Section 4 of the Constitution. And therefore, for the honourable member to try and shrug it off and say, no, I'm talking about a right to work. I mean, come on. The honourable member has served in multiple capacities, and I would like him to just simply admit to the truth of the fact that he was really referring to the right to property. Not very well. And Madam Speaker, as to whether this law trips the right to property, the right to property is an enshrined right in Section 4 of the Constitution. The right to property is not an absolute right. The right to property has been obviously the subject of derogation. It has been anchored since 1964 in the West Indian Law Reports. The case is Inland Revenue Commissioner versus Lillyman. 1964 West Indian Law Reports at 496. You are entitled to take away somebody's property, quite properly even though it is enshrined, if it is for taxation. We do that every single year in respect of taxation. You would never guess that the member for Caroni Central has been in the Parliament since 1986. Because it means that there was no attention to the right to work, stroke the right to property, from 1986 onward, every single year when we affect people's rights to property, i.e. their money is defined as property in the Lillyman case, Madam Speaker. So come on, Caroni Central, with the greatest of respect. Those arguments are just infantile, Madam Speaker. And here the honorable member, those are 3/5. Which finance bill in this country passed with a 3/5? Name one. I will sit.
Sit till tomorrow.
Right, you talk. You talk. Name, the honorable member can name one single finance act that was passed with a 3/5 majority. You know why? It just cannot be the case. It is hogwash. It is intellectual absurdity to make the submission that my learned friend just did. Intellectual absurdity, Madam Speaker.
Order.
So, Madam Speaker, as to whether the right to property is infringed, number one, Trinidad Island-wide Cane Farmers Association versus Prakash Siraram. In that particular case, 1975-27 West Indian reports at 329. Again, the issue of compulsory cess was considered. The court clearly acknowledged that you can infringe upon the right to property. You can infringe upon somebody's money which they earn by work, Madam Speaker, if it is for a public institution, a public purpose, for the public benefit. That's why I took care to say it so many times when I piloted the bill, Madam Speaker. That was upheld in Attorney General versus Antigua Times. That is to be found 1976 appeal cases at 16, a judgment of the Privy Council. That is to be upheld in the case of Keller versus the State Bar of California. That is to be found at 496 US 1 at page 12. So I've taken American jurisdiction, Privy Council dicta, and Trinidad and Tobago Court of Appeal Authority to rubbish the argument presented by my learned colleague for Caridi Central. Madam Speaker, in any event, if we are talking about the fact that people can't work because they can't get a license, because they're not a member of the Urban and Regional Planners Authority, the law is equally clear on that. It is clear in the context of the Legal Profession Act, the Dental Profession Act, the Medical Profession Act, the Land Surveying Act. You cannot practice as a professional under those 4 pieces of law at the Architecture Act unless you are licensed by that body. And when Tabakit says that he will not be part of a parliament that passes law like that, I will remind Tabakit that with the benefit of internet facilities in this parliament, I Googled him. I went to his Wikipedia profile. I went to his parliamentary profile. I looked at his tenure in the parliament, 1987 onward, and I found evidence of the honourable member, my dear friend, the member for Tabakit, having sat in parliaments that amended the very laws that I've just referred to, the regulatory bodies, many times, and therefore, the honourable member, I think, has just had a small lapse in memory, perhaps in his haste to leave the UNC, much like Barataria Sanwan, having been filled with their, how should I say, their tiredness for the UNC. Perhaps my learned colleague forgot about those sessions in Parliament where he contributed to the very thing that he says he can't do today. But I don't hold that against Tabakit. I take the benefit of some of his submissions later on as he focused upon corruption and mismanagement, etc. There was a point made by Caroni Central. Caroni Central was telling us, Madam Speaker, that effectively we are going to put people out of business because they're going to have a liability on them. It provoked Diego Martin Northeast, the Minister of Finance, to ask him certain questions for which he was restrained a little bit by the chair. But the point is, Madam Speaker, this law, much like the architects' governing provision, land surveyors, engineers, etc., this law proposes that you will have to have a liability visited upon you. And therefore, this law is no different from the many laws put into effect. But what got me, Madam Speaker, what really got me in the bold-faced submission coming from Caroni Central, oh, you're going to put people out, this professional indemnity aspect that then came up afterwards. Madam Speaker, Act number 10 of 2014. Assented to 1st of October 2014. Guess who the minister was with responsibility for piloting that law and asking for the assent? Carney Central. Then Senator Dr. Boindradat Tiwari.
Easy with them.
The minister with responsibility. Hear this!
Not easy.
Part 7, listing of professionals. Right? Passed by the honorable member. Governing body, architects, engineers, land surveyors, urban and regional planners, so defined in section 73. Section 74, it must be by a registered professional. Section 75, a professional governing body shall establish in relation to the profession it regulates minimum levels of professional competence required for preparation, such categories of approvals, etc. Section 76. The National Planning Authority may, after consultation with the professional organizations, fix the minimum amount of any performance bond or other financial guarantee required to be provided in respect of professional certification of approvals and submissions. 77. Applicant must satisfy minimum levels of professional competence. The professional body shall issue certificates of competence. And then it goes on, Madam Speaker, to actually say that the register must be maintained and that a listed professional in Section 82 who fails to comply with a prescribed mandatory requirement or honor his obligations, any other cause exists, the National Planning Authority considers appropriate to terminate the approval of submissions, etc. The professional governing body shall show cause why the name should not be removed, etc. I am basically reading out the sections now that say that the fixing of liability for the urban and professional planners, which the honourable member had so much hatred for and contempt for and concern for, it's anchored in the very bill that he passed in Act number 10 of 2014.
Oh, yeah.
But it shows that the honourable member did not even bother to read the law that from which this act proclaims its origin.
Difficult for him.
And it is hard to take an honourable member seriously when he's saying this law is contemptuous for a reason which exists in a law that the honourable member passed and piloted as the minister with responsibility. I mean, come on, Madam Speaker.
Would the honourable member give
No,
Sure.
but why so?
Madam Speaker, the honourable member spent his time chastising me for something I did not say. The only thing I said in relation to that clause which he mentioned about indemnity, I asked the question, how are the liabilities incurred by the people who are affected by a decision of someone who is covered by indemnity going to be allocated? Another member of this House did speak to the issues that he's speaking, but it is not me. He is making an error.
For his explanation, my notes say otherwise.
Of course.
Tabakit,
No, he's not going to speak.
Tabakit made some contributions. Couva North was contributing on some other piece of law. We're not quite sure.
So, you know, in the local parlance, we say, do so, do like so. Okay? So I have allowed you, you've corrected from your perspective. The honourable member on the other side does not accept, but it's the only answer. And just as on the last occasion, I think you, honourable member, took exception to being interrupted. I think we should afford the Attorney General the same courtesy. Member for San Fernando West.
Thank you, Madam Speaker. I'm grateful for your protection. I don't mind the crosstalk at all. I know you're keeping order otherwise. I take no offense from the honourable member. I give way when asked to give way. I'll just put that on the record, okay? So the member has put his position there. The honourable member for Caroni Central went a little bit further. Hear this one. They, meaning the PNM government, this government, they want to control who could get what.
Control, yes.
Imagine that.
He says that there will be a rebellion against this oligarchy. That's what the honourable member had to say.
Words.
The honourable member again comes with the concept. He has a good smile on his face right now. The honorable member says there will be a rebellion against this oligarchy
understand what you're
because they want to do what they want. Because they will say who can get planning permission, how they will get planning permission, and who wouldn't get. Madam Speaker, is this the same honorable member who was the subject of judicial review proceedings to compel him to give in open form the advice in the JCC matter, where they were given away in breach of the Central Tenders Board Act, the Invaders Bay property? This could not be the same honorable member.
Himself.
This could not be the same member who, as Minister of Planning, approved SIS's insane project to build a wastewater treatment plant in central Trinidad. This could not be the same honorable member who witnessed the contractor SIS run away from Trinidad and Tobago to Panama, the only country close by that has no extradition treaty with Trinidad and Tobago. This cannot be the same member who watched his prime minister bring law to affect the rights of citizens, because this honorable member said that that government was interested, the UNC government was interested in land and tenure and benefit for people of Trinidad and Tobago. That member, Minister for Planning as he sat, allowed 2 pieces of law to be laid under the UNC: squatter regularization and then security of land tenure bills, both of which were caused to lapse after I spoke. Because after I spoke in those debates and I demonstrated that the bill that they brought to declare squatting in areas capable of being recipients of certificates of comfort, that bill did not have the planning order it was supposed to have under Section 10 of the planning laws that still prevail in this country. And that Minister of Planning, as he then was, sat down and described squatting areas as follows: Monrepo, San Fernando, Manambre. I mean, come on. We're supposed to listen to the honorable member for Caroni Central today? Really? Incapable as a Minister of Planning of defining what Manambre is, what Monrepo is. Lower Hillside, I'll never forget that. Lower Hillside, the whole of Lower Hillside was a squatting area. Where it starts, where it ends, Madam Speaker.
Don't give way to it.
Honorable member,
Don't give way.
short on time. Yeah, the honorable member did not bring the bill. The honorable...
Again, okay? And the only reason why I am being so particular is that I say I always understand Banton, particularly between the front bench on the left side and the front bench on the right side. But, you know, seeing that some people take umbrage to it, I would really ask that, you know, we do as we like.
Thank you. The honorable member did not bring the bills. He takes full authorship and ownership of the JCC decision for hiding the legal advice. Because the Court of Appeal said so, right? Albeit that he was led along the wrong path, surely by Anand Ram Logan, the Attorney General, who told him not to disclose the breaches of the law. By the way, the same thing happened in the Central Tenders Board breaches for the jails and courthouses they were supposed to build. But anyway, it was in fact the member for Oropuch East who laid the other 2 bills. But my point is, bills do arrive here without cabinet approval, and those bills to treat with boundaries and development issues and orders to be issued under the town and country legislation, it is that minister then, the Minister of Planning, the member for Caroni Central, as a senator then, who had responsibility for that. So you can't disassociate yourself and cleave yourself out of the wrong decisions that the entire cabinet took part in, Madam Speaker. If it was so good, they would have finished the law, but they didn't. They had to abandon the law, Madam Speaker. Madam Speaker, we look to constitutionality in the round by saying there's a legitimate aim, it is rationally connected to the purpose, it goes no further in intruding upon existing rights than we ought to if you were to accept that there's an intrusion at all. In fact, Madam Speaker, Baroness Hale was very careful in paragraph 58 of the Surat judgment to set out, apart from saying that not every 4 and 5 right of the Constitution must be considered in a Section 13 context. The Honorable Baroness Hale said specifically, it is all the much more so the case that you don't need 3/5 majority when you are dealing with what is the status quo. You're going no further than existing parameters allow. And therefore, I need only say architects legislation, engineers legislation, dentists legislation, land surveying legislation, all of these medical regulatory body, all of them are passed with simple majority post-1976, and therefore we are not going any further than we must. I don't think there was anything to respond to in Couva North's contribution, and therefore I beg to move.
Honorable members, the question is that a bill entitled An Act to Establish a Council for Urban and Regional Planners and to provide for the regulation of the urban and regional planning profession and other matters incidental thereto be now read a second time. All in favor say aye. Aye. Any against? The ayes have it. The attorney, the clerk.
An act to establish a council for urban and regional planners and to provide for the regulation of the urban and regional planning profession and other matters incidental thereto.
Attorney General.
Madam Speaker, in accordance with Standing Order 68-1, I beg to move that the Urban and Regional Planning Profession Bill 2019 be committed to the Committee of the Whole.
Honorable members, the question is that the Urban and Regional Planning Profession Bill 2019 be committed to the Committee of the Whole. All in favor say aye. Aye. Any against? The ayes have it. This House will now go into the Committee of the Whole to consider the bill clause by clause.
Please circulate the amendments.
Clause 1. The question is that Clause 1 stand part of the bill. The question is that Clause 1 now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clause 1 now stands part of the bill. Clause 2. The question is that Clause 2 stand part of the bill. Attorney General.
Madam Speaker, the government proposes that we delete the Clause 2 as set out in the bill, which was where we would be asking for a special majority, and that instead we insert Clause 2, which is for the act to come into effect by way of proclamation. It is therefore in terms as set out in the draft circulated, and that's the rationale for it. We've already laid the ground as to why this bill does not require 3/5 majority in the debate, and I adopt those submissions.
Whip.
Chair, Clause 2 is where you removing the 3/5, correct? Yeah. Are you now also changing the preamble has to change?
That will automatically fall by the wayside, so there's no need to move for that to be amended. It'll just fall away.
I'm just asking a question.
Central, you have a question or contribution?
I'm looking at the amendment without the page of the bill, but the Is the deletion the solution to the AG's problem? Is that how you're doing it?
Yes,
You're simply deleting the clause.
delete and replace with a commencement clause instead. So that way we don't have to do numerical replacement or cross-reference changes.
Okay. Well, I would just like to indicate that we object to the change.
Noted.
The question is that clause 2 be amended as circulated. Those in favor say aye. Aye. The question is, I'll repropose the question. The question is that clause 2 as be amended as circulated. Those in favor say aye. Aye. Those against say no. No. The ayes have it. The question is that clause 2 as amended now stand part of the bill. Those in favor say aye. Aye. Those against say no. No. I think the ayes have it. Can we go from 3 to 59?
Clauses 3 to 59.
The question is that clauses 3 to 59 stand part of the bill. The question is that clauses 3 to 59 now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clauses 3 to 59 now stand part of the bill.
Clause 60.
The question is that clause 60 stand part of the bill. AG.
Madam Chair, we propose the insertion of a subclause 3 as circulated. This is specifically so that we can derogate from Section 63 of the Interpretation Act. And if we had not included this, we would be confining ourselves to a breach of the regulation standing at $500 TT. We're proposing instead that regulations under this section can prescribe that a contradiction can be punishable by an offense triable on summary conviction, by a fine not exceeding $15,000 and a term of imprisonment not exceeding 2 years. Thank you.
The question is that clause 60 be amended as circulated. Those in favor say aye.
Aye.
Those against say no. I think the ayes have it. The question is that clause 60 as amended now stand part of the bill. Those in favor say aye.
Aye.
Those against say no. I think the ayes have it.
Is it 61? Madam Speaker, there's a 61.
Clause 61.
The question is that clause 61 stand part of the bill. The question is that clause 61 now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clause 61 now stands part of the bill. Thank you, H.
Schedules 1 to 8.
The question is that schedules 1 to 8 stand part of the bill. The question is that schedules 1 to 8 now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. The schedules 1 to 8 now stand part of the bill. Members, as a result of the deletion of clause 2 in its original form, the question is that the preamble be deleted. Those in favor say aye. Aye. Those against say no. No. I think the ayes have it. Honorable members, having regard to the deletion of the preamble, the consequential changes will be made to the certificate. Honorable members, the question is the bill as amended be now reported to the House. Those in favor say aye. Aye. Those against say no. I think the ayes have it. This meeting is now suspended. The House will resume. Attorney General.
I wish to report that the Urban and Regional Planning Profession Bill 2019 was considered in Committee of the Whole and approved with amendments. I now beg to move that the House agree with the report from the committee.
Honorable members, the question is that this House agree with the committee's report on the Urban and Regional Planning Profession Bill 2019. All in favor say aye. Aye. Any against? The ayes have it. Attorney General.
Madam Speaker, I beg to move that a bill entitled An Act to Establish a Council for Urban and Regional Planners and to provide for the regulation of the urban and regional planning profession and for other matters incidental thereto be forthwith read a third time and passed.
Honorable members, the question is that a bill entitled An Act to Establish a Council for Urban and Regional Planners and to provide for the regulation of the urban and regional planning profession and other matters incidental thereto be forthwith read a third time and passed. All in favor say aye.
Aye.
Any against? I think the ayes have it.
Bill entitled, An Act to Establish a Council for Urban and Regional Planners and to provide for the regulation of the urban and regional planning profession and other matters incidental thereto.
Leader of the House.
Thank you very much, Madam Speaker. Madam Speaker, I beg to move that this House do now adjourn to next Friday, the 22nd day of November 2019 at 1:30 p.m. Madam Speaker, next Friday being the fourth Friday of the month, it's Private Members' Day, and if my colleague can alert me as to what we'll be doing then.
Thank you, Madam Chair. We'll be doing motion number 1 on Private Members' Day for the people.
Honorable members, the question is that in accordance with Standing Order 11 and 12.1, this House do now adjourn. All in favor say aye. Aye. Any against? I think the ayes have it. This House now stands adjourned to Friday, the 22nd of November, 2019 at 1:30 p.m.